Welcome to Debt Matters. For any business or, even for an individual, there's nothing quite like that sinking feeling of an unpaid invoice. It just sits there and, you need that cash flow, but you're stuck.
Okay.
And then comes the big question. What do you actually do about it? Do you try to negotiate or do you just go straight to court?
That really is the critical decision point, isn't it?
Yeah.
Today, we're going to compare the two main paths for getting that money back. Mediation, which is really a facilitated negotiation, and litigation, which is the formal court process. We're going to break them down based on what really matters to you, what does it cost, how long does it actually take, and what kind of result can you expect at the end of the day.
Right. So this is really about collaboration versus confrontation. Let's get into the pros and cons.
Okay, so first, we have to be really clear on what these two things are. They sound similar, but they're fundamentally different. Mediation involves bringing in a neutral third party, a mediator, and their job is not to be a judge.
So they don't decide who's right or wrong.
Not at all. Think of them more like a communication expert. They're there to help you and the debtor find some common ground to work towards a settlement that you both can agree on.
An agreement you both create.
Exactly, and this is the key. It only becomes legally binding if you both voluntarily sign off on it. It's all about mutual consent. Litigation, on the other hand, well, that's the complete opposite. You're filing a lawsuit. You are officially in the court system.
And at that point, you lose control.
You've handed over all control. The outcome is decided by a judge, maybe a jury, and what they say goes. You get a court-ordered judgment that's legally enforceable.
So that really clarifies the immediate trade-off. With mediation, you're in the driver's seat. With litigation, the court is, and you have to go wherever the judge tells you. But what if the debtor is just completely unreasonable? They're dodging your calls, you suspect they're hiding assets. Isn't mediation just a waste of time then?
That's a very real concern. And look, if you're absolutely certain they will not negotiate in good faith, then maybe. But what we often see is that the formal structure of mediation can actually bring people to the table.
Why is that?
Because they see the alternative. They realize that if mediation fails, the next step is a much more expensive, much more public court battle. Sometimes just the threat of litigation is enough to make mediation seem like a very attractive, cost-saving option for them, too.
That makes a lot of sense.
Okay.
Let's get into what everyone is probably thinking about right now. The money. How much do these two paths actually cost?
The difference is pretty dramatic. Mediation is, by its nature, designed to be lower cost and, crucially, more predictable.
Predictable is a good word when you're already worried about cash flow.
It's a huge deal. With mediation, your main costs are really twofold. You have the mediator's fee, which is often split 50-50 between you and the debtor.
And what does that typically run?
It can vary, of course, but you might be looking at, say, $1,500 to $5,000 for a full day, and then you have whatever time your own lawyer spends preparing. But the total is usually in the low thousands. You can budget for it.
Okay. You can see the expense and plan for it. Now, litigation.
Litigation is a whole different universe. The costs aren't just higher, they can be unpredictable, and they can spiral.
How so?
Well, you start with an initial retainer for your attorney. That could be $10,000, $20,000, even $50,000 just to get started. Then you have the hourly fees piling up.
And it's not just for the courtroom time, right?
Oh, not at all. The real cost driver in many cases is something called the discovery phase. This is where the lawyers spend hundreds of hours gathering evidence, reviewing documents, emails, financial records.
So you're paying your lawyer maybe $400, $600 an hour just to read through boxes of old emails.
That's exactly it. And that part alone can run into tens of thousands of dollars before you're anywhere near a trial. And that's not even counting things like expert witnesses. If you need an accountant to testify, for example, that adds thousands more.
It sounds like the process itself just creates these enormous costs, whether the debt itself is complicated or not.
That's a perfect way to put it. The cost is procedural. With litigation, you're paying for a guaranteed legal judgment, yes, but you're also paying for a mandatory and often very expensive process to get there.
Okay, so we've covered the financial drain. Let's talk about the time drain. If you need that money for payroll, every week counts. How fast can you get a resolution?
On this front, it's not even a contest. Mediation is built for speed.
How fast are we talking?
I mean, you could have a resolution in a few weeks. For a more complex issue, maybe a couple of months. The schedule is flexible because you and the other party are the ones setting it. You decide when to meet.
You control the calendar.
You do. If everyone wants a quick resolution, you can get one. It's designed to be efficient.
And litigation. I think we all have an idea of what that looks like.
It's the definition of slow, a slow procedural grind. It's not unusual for a case to take a year, 18 months just to get through the initial stages, and that's if things are moving smoothly.
And that's before any potential appeals, I imagine.
Exactly. An appeal could add another year on top of that. The most frustrating part for many businesses is that you have absolutely no control. You're waiting on the court schedule, the judge's availability. You're just stuck waiting.
And while you're waiting, you're not just out the money. Your team is tied up, right? Someone has to manage the lawyers, pull documents. It's an ongoing operational headache.
That is such a critical point. It's a hidden cost. Litigation forces you to run your business while also managing a lawsuit in the background, sometimes for years. Mediation lets you solve the problem and get back to what you're supposed to be doing.
All right, let's move to the outcome itself. Beyond just getting paid, what do you actually walk away with from each process?
The outcomes are fundamentally different. With litigation, when a judge makes a ruling, it's very rigid. It's typically a monetary judgment. You are awarded X dollars. That's it.
It's a win-or-lose situation.
It's binary, yes. A judge isn't there to craft a creative business solution. They're there to apply the law. And another thing, court judgments are public record.
Oh, so anyone could look it up.
Anyone. Your dispute becomes searchable online, and of course, a lawsuit is basically a declaration of war. That business relationship is over. Guaranteed.
So if it's a client you've had for 10 years who just hit a rough patch, litigation means that relationship is completely severed.
It's the nuclear option. Now, contrast that with mediation. Because you're both building the solution together, you can be incredibly creative.
What do you mean by creative?
Well, it doesn't have to be just a simple cash payment. Maybe you agree to a structured payment plan. Or maybe they give you a discount on future services in exchange for forgiving part of the debt. You can find solutions that actually benefit both of you long term.
Things a court would never order.
Never. And the entire process is confidential. It stays behind closed doors, protecting everyone's reputation. And maybe the most important thing is compliance.
Meaning, do people actually pay up?
Right. Because the debtor helped create the agreement, they have a sense of ownership over it. We see a much higher rate of people voluntarily complying with a mediated settlement than with a court order that was forced on them.
That makes perfect sense. The goal isn't just to get a piece of paper that says you're owed money. It's to actually get the money.
Yeah.
Okay, so to wrap this up, the core trade-off seems to be this. Litigation gives you that ultimate legal power, that state-backed enforcement, but it comes at a very high price in money, time, and flexibility.
It does. And mediation is the flip side. It's fast, it's cost-effective, and it allows for flexible solutions that can even preserve a valuable business relationship. So the choice really boils down to your top priority. Is it getting absolute legal certainty no matter the cost? Or is it getting your money back quickly, controlling your expenses, and maybe keeping that business connection alive?
Understanding that choice, the high cost of certainty versus the value of speed and flexibility, is really what helps you make the right call.
And let me leave you with one final thought. In a lot of places, you're encouraged to try mediation before you can even file a lawsuit. But choosing to sue as your very first move, that's an irreversible step. You're burning that bridge. So before you make that call, ask yourself, what is that professional relationship actually worth? How does its value stack up against your need for an immediate court-enforced order to pay? Answering that question can change your entire strategy.